Practice. And it seems you won't be able to come the whole month. So kindly to be listed after 6 weeks.
In that case, do you need any fix it? Because he generally comes from Guwahati
This we just told you
after 6. Heard Mr. So appearing on behalf of Mr. P.D. Nayan, the learned leading counsel. And also heard Mr. J. Sering, the learned PP for the state of Assam respondent. It is submitted that due to some personal inconvenience, the leading counsel, Mr. P.D. Nayan, is not in a position to appear before the court today. They are allowed, we will release the matter accordingly after 6 weeks.
there is
Interim we continue till next date of this.
much of it.
Respondent number who was supposed to file the affidavit? Who is respondent?
Pleadings completed, but
Completed.
completed.
You have already filed the affidavits.
Well, yes,
So you
I
are
filed
appealing
the
for
affidavit.
respondent number 2
My lord, I'm for one,
for 1.
yes.
And who is appealing for 2? Is there?
Two is, I don't know how come two has been increased.
No, here it is written an affidavit is not yet filed on behalf of respondent number 2.
So
Counsel is there, my lord.
Huh? Two is,
He's in other court. He's coming. He's on the way. In fact, he instructed me that two is just the performer respondent. So,
no, not performer.
not performer.
I have-
However, he's
I have alleged Melafaidi.
uh,
In person, I have made him as a party in this case.
then he is not performer.
Not performer.
not exactly performer. However, he
Not
said-
performer, therefore he has filed the affidavit in opposition also.
No, number 2 has not filed. He has
Two,
already
two
filed.
has filed.
Oh, filed. Then
Filed.
yes, officer as per officer not yet filed. That's what I'm asking. When
filed case.
I have received a copy on 16/11/2022, my lord.
16/11,
My lord, I have received a copy.
but here it is as per office note by dated 2/8/2020, that is the
It means
for yesterday affidavit not yet filed on behalf of respondent number 2.
there must be some mistake from filing section. Madam. Yeah, that's-
Oh, acha,
It
yes.
is filed.
Otherwise you have received, they have already filed.
Huh.
And one you have also filed.
Yes, I have already filed.
Oh.
Mistake.
Then do one thing, we can admit this one. Or if pleadings are completed, can be admitted, or in the otherwise also it is for the admission hearing.
My lord.
And in that case, is any LCR etc. required or not?
LCR will be required.
LCR will be required.
Huh.
This is, my lord, actually, I raised the maintainability issue in this case.
Maintainability.
Maintainability issue. If the maintainability is considered, my lord, if it is established is not maintainable, then this entire matter goes on without entering into merit.
In that case, it is,
Because-
the admission hearing regarding admission hearing maintainability has to have,
Yes.
to be
yes,
had.
Yes,
So
so my submission, my lord, my humble submission is that, my lord, this is the appeal against the judgment passed by the customary court. My lord, there's Arunachal Pradesh Civil Court Rules Act 2021 provides the appeal against the judgment of customary court. Now here, instead of filing an appeal before the appropriate forum, this involve
Indirectly come
the
before the high court.
civil revision petition, which is not maintainable. It is settled, my lord. Even in various effects for judgment as well as in our own high court.
Acha,
So that aspect only
okay then.
ultimately matter has to be placed before the appropriate forum only. What my understanding, madam, subject to the,
In that case, I am ready to argue on that aspect.
Pardon?
I have filed this revision
Hmm.
under 227. The supervisory jurisdiction, not under 115.
That is,
If suppose any court without having any jurisdiction or there is some jurisdictional error, of course, 227 can be invoked. There is no bar. So on maintainability, I am ready to argue.
So what to do? You want to argue this one today or now other side, number 2 is absent. He will be coming, he will be the other court.
Yes, in fact, he informed me that he doesn't have much to say on this because
They are from same chamber, I think.
no.
he has just informed me, he
Okay.
told me. Because I'm informing what he has instructed me.
In that case, my lord,
Yes, can-
some other date,
If
Next week
some
can be
other-
fixed, I think, otherwise.
next week, my lord, in that case, it may be on 9th.
9 and 8 and 9, there are. Okay, then you can fix, I think so, 9, can fix on 9.
For admission,
Okay.
there is a.
Admission hearing will be there on the maintenance.
Yes, yes,
Will
yes.
be heard.
Yes.
Heard Mr. K. Nama, and your good name was?
T Tagu, my lord, Tawa
K.
Tagu.
Tabung, the learned counsel for the respondent number 1.
Yes,
It is submitted by the learned counsel for the respondent that the present revision petition is not maintainable. And here they have already raised the issue of maintainability. Full stop. Let the matter be accordingly listed on 9th of August 2022 to hear on admission as well as on the maintainability issue. On 9th.
deeply obliged.
Interim order, maybe
Interim was there, interim be continued till next date of listing.
highly obliged.
Now, this is fixed for admission. Why it is fixed for admission actually? This is RSA, no?
This is second appeal, my
Then-
lord.
Second appeal. Then the duty of the court is to don't be substantial questions of law.
We have filed in the form of affidavit in opposition that the proposed substantial question of law are not substantial question of that cannot be framed. So therefore, it needs a
Hearing.
consideration today. We have filed it in written form also. There, every proposed substantial question of law. Let my senior brother argue, my lord. There is no any substantial question of law in this case.
But otherwise also I'm asking, the substantial question of law, they have already submitted or they have furnished. As per you, these are not at all the substantial question of law and you have filed the affidavit also.
Well.
But we are to here because most probably court has not formulated any question of substantial question of law
Well.
till now.
My lord.
So if you want to argue that matter, because substantial question of otherwise the actually in RSA admission will come later on after substantial question of law
Right.
formulated, but whatever.
Yeah.
Here it is, you have already most probably furnished. In which page you have furnished? Do you want to argue this matter?
Yeah,
Yes, okay.
substantial questions of law.
Your substantial question of law, I think page number, which page number?
Page number.
16.
Huh?
16.
16?
16.
So we have almost framed 7 numbers of substantive question of law.
Yes.
Okay.
Whether the uninstalled document has completely lost its credential,
Number 1.
number one. Here in the case, we were ready to adduce an agreement. And that is simple mortgage. But no doubt, that document was not in our possession. But later on, after the judgment in the senior division civil court, after pronouncement of judgment, the original document was found. Then we attempted to produce it in the appellate stage. That is under 47 rule 41 rule 27. Here the consideration was that unregistered document cannot be used. That is one of the question that whether it looks is credential. What law says? Even it may not be unregistered, but it can be used as a corollary. So that submission was not taken into consideration, and it becomes a question of substantial law. Another, whether the witness can depose against the term and conditions of the agreement. Both of us make an agreement. Terms, all the conditions have been laid down. Can I completely change the entirety of term and condition of that agreement? The money was borrowed by the present respondent. I was guarantor. I repaid the loan. Then the landlord, the money who had given us, then he said, no, this money was not borrowed by that society, but that money was borrowed by the present. Can it be this permissible in the law? Is it not a substantial question of law? If it is allowed, then there would be no meaning at all for making of any agreement. Can he deny? Can he completely change? And only because of that, the entire picture of the case is changed. That is substantial question of law. Whether it is substantial question of law or not, it is court to be decided. Now, third point, whether a witness can be allowed to give evidence contrary to the content of document executed in between the parties. Now, there are two things. In the second question of law, an agreement was made between both of us. There was a witness. Whether witness can rectify the term and condition. Yes, it was not the term and condition. Being a witness, he can rectify, he can make the correction. Being a witness, but not the party. That is also a substantive question of law. Now, another is whether a witness can be allowed to give evidence contrary to the content of document executed in between the parties. This third one is two persons made an agreement. He put his signature. Can he deny it? He is not disputing his signature. He admitting it. Can he deny the term and condition which is given in the agreement? If it is allowed, there will be no lawlessness, because binding is on the term and condition, and they are not disputing the document. That is a substantial question of law. It is not a mere fact. Now, whether the oral evidence without ambiguity and consistency statement is admissible in law. From very beginning of my general statement, I always say that I was made as guarantor and the money was borrowed by the plaintiff. And as per the condition of the pledging of guarantor was that if I will not repay the amount, fail to repay the amount, you keep the patent disputed land. From very beginning. And on the basis of that, I became the guarantor. And the plaintiff did not repay the amount. I repaid the amount. After that, the land transferred to me. So this oral evidence without changing and consistency, how it is not admissible? Now, whether a witness who is not a party to the agreement can do the correction of the content of the document. He was not party to the case. But law says that being a witness, he can make the correction upon the content of the agreement. This is also not a fact. It is a substantial question of law. Fourth, whether the application to adduce additional document under Order 8, Rule 1A, 3, bar the parties to file application under Order 41, Rule 27, additional evidence at appellate stage to bring the record additional document which is at different stage. I filed a petition under Order 8, Rule 1A, 3, for addition of additional document. It was rejected. But after adjustment, again, while I appealed, I filed the application under Order 41, Rule 27 to adduce additional evidence at appellate stage to bring in record additional document. Now, once it is a petition was filed, it was rejected under Order 8, Rule 1A. Whether it will bar to file additional document, additional evidence in the appellate stage. It is not a fact. It is a matter of substantial question of law. Because filing of additional document under Order 8, Rule 1A, it is the trial stage. Trial stage. There it was rejected. Can I not file the additional evidence, additional document in the appellate stage? There is a clear cut rule. So how it can bar? Now, this whether the court can rely the prosecution document when the prosecution witness has denied it. Now, here in the case, Tetsukato is the PW2. He himself says the term and condition written in one mutual agreement is not the actual facts which was discussed in the meeting. This is not my witness, but he is completely denying that the content of the agreement, mutual agreement, is not the subject matter which was discussed in the meeting. Means in the verbally they have stated different, but in agreement they have written in different. And the PW2 is an illiterate person. And GW1 is an illiterate person. They were signing. Later on, they came to know that the agreement were their own good faith. They have signed. But later on, it was found that it is completely untouched thing, which was not discussed at all. It was written in the agreement. So these 1 to 7 are the substantive question of law. It is, I am not submitting. I'm not submitting based on the fact. I'm submitting on the basis of the law. Now, at this stage, respondent has no vested right. Vested right. It is appellant and the court. I must satisfy the court whether there is a substantive question of law or not. So I have established clear-cut established that there is a clear-cut substantive question of law is involved. So my submission is that this court may drown the substantive question of law, which I have put forward before this court. As per Section 100, Section 100, subsection 5, respondent has no vested right. Proportionate discretion of the court for formulations of questions of marriage. Now, it is the court. What is his vested right? My duty is to satisfy to the court whether the certain question is involved or not. He will be given ample opportunity to argue at the time of the hearing. It is for the admission. So, substantial question may be told, and he will be given ample opportunity to argue. This is not a case of argument. Law says, what law says? That the appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, they are allowed to argue that the case does not involve such a question. Provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear. For reasons to be recorded, the appeal in on any other substantive questions of law not formulated by it, if it is satisfied that the case involves such questions. Now, it is between the court and the appellant. What is his right?
Now, this is true, but the question is that the substantial question of law has to be formulated before issuing notice, but that has not been done. So in that case, the respondent had already appeared, the notice has already issued without being formulated the substantial question of law. That is the point now they have appeared, and we have to hear the other side also on this point. Otherwise, it is you have rightly corrected that it is the duty of the court to formulate the question of substantial question of law. If this substantial question of law exists, then and then only the appeal should be admitted and notice should be go. But here in this case, as already respondent has appeared, so definitely they will have the right to argue. That is the main issue. So let us see. They have already filed most of the
affidavit in opposition, in the form of affidavit in opposition, but then objecting that those proposed formulation substantial question of law are not substantial question of law. And in our affidavit in opposition, we have substantiated all the justification that we have given with the Honorable Apex Court judgment. All the proposed formulation of substantial question of law, that is from serial number
1 to 7.
Roman 1 to
7, I think.
7 are not substantial question of law as per the decision of Honorable Apex Court. I'll be placing all those citations.
Now, I'm just asking you, if these substantial question of law are being furnished by you, so getting the opportunity of being appeared no sound, now they have already filed the affidavit in opposition. So they now are going to argue all these matters as per the respondent. These are not at all the substantial question of law. Are you prepared today to reply back or any? So that's why I'm asking. Now matter may be disposed of finally also. If there is, or yes, rather what can we do? Suppose after hearing them, if the court says that these are may or may not be the substantial question law, but as per court, there may be some other substantial question of law which the court has the right to formulate. In that case, it will be heard finally. But if suppose these are not the question of our question, substantial question of not at all arise in the second appeal, in that case, it may be finally disposed of also. That's what I am asking you. If you are ready to hear the other side completely, or I don't know what will be stage.
Oh.
Have you received the copy of the affidavit in opposition? Affidavit, copy of affidavit in opposition you have received?
Yes, we have received.
Yes, already received, you have seen.
Earlier we have.
Oh, okay. Then it's okay, then we can hear the matter.
Hearing.
Yeah. I have not been so. Now I've seen.
So okay, then we start. Okay, I start, you can hear the other side. If you are ready, we can hear the other side, because they are going to submit on these questions and even by placing some authorities also. So that's why I'm.
Let's fix it on Monday.
Monday cannot be, because last week, next week, I have lots of cases, I have already been fixed. So most may not be possible. If I ready today, then otherwise next week may sense it may be.
I'll go for the content of the apex. I haven't seen it. I was not informed.
Not being informed by whom?
The copy which was received by the juniors, they were not handed over to me.
Because that's why I'm asking you, because they have already prepared the affidavit in opposition and ready to argue. So if you are ready, I can hear. We are.
Next week.
Next week, within Friday, I cannot give. Lots of cases already been fixed. I'm leaving on Friday, so Friday we are not going to give. Then in that case, it will be, we'll put it next week only, but it may go up.
9.
9, I cannot. 9 and then it will not be possible.
In that case, my lord, 8.
I don't think so. I don't know. It already good fixed.
Bank on that.
7. Lots of cases are there. 9 to already 1 I have fixed today. This is also a matter to be heard on 9.
10, 11, my lord, I'll be
11
having some
to- 11 to
difficulty.
not at all possible.
11, I will be also having difficulty.
Not at all possible. The 10 can be given, 10.
Huh?
10 can be given.
10,
10th of
my lord,
August.
I'll be having some difficulties, my lord.
Then you can go for the next week. What I don't have it already.
Next week, my lord, 14, 15, any
Yes,
day.
yes, that can be.
As per my seniors.
That can be important.
14, 15.
15.
My lord, maybe on 15.
No, 15 is 15 others. 15 others. So 15 is on 12. Then
My grandfather was dead. Now he's dead. So he was very serious and serious mood. He was asking someone, a relative, इस बार 15 अगस्त कौन सा डे में पड़ा है? He was confused. 15 अगस्त केचिया पुंडराय के पुलिस से he was also confused. So later said, "Ki kuda mama itu jo 15 August is a 15 only." Anyway, the 15 will not be possible. Either you can make it on 14th.
16 will be.
16 can be.
6,
Otherwise, I can give you in my presence if you want to argue, then I can give you 8. Oh, sorry, 10.
16.
11 I cannot give. 10 can
16.
give it 16. Okay, then.
16.
16. So go by the affidavit in opposition, though matter may be.
If necessary, they can file rejoinder also.
Yes. If it is necessary, you can assist your senior. So can be filed. If there is any, because if the matter is heard finally, though the possibility of final disposal may be also there. That's why I
Yeah.
asked. It may be disposal.
Because we are assisting this honorable court only. If suppose those proposed substantial question of law cannot be as per the authority pronouncement of honorable apex court, then that would be wrong from our side to we have to give proper assistance. Then highly
We
obliged.
need actually, we need your assistant cooperation definitely, otherwise how can we? Okay. Then I'm going to fix it on 16th.
16.
And as for if you have any other reason and etc., you can give us, submit us.
Okay, I mean,
Up to 9th, I am going to hear all the matter, but 10 and 11 for will be difficult for me. 11 to not at all.
Friday, my lord, will be difficult. Highly obliged.
Okay.
Number 4.
Item number 4.
My lord,
Other side they also appeal. No,
No, Your Lordship.
not the three name of three councils are already being reflected in the constitution. You're appealing
They're from the
On
same
both-
chamber.
I'm appealing.
for, you're appealing for?
Respondent number 4.
Oh,
Informal.
he was the informant.
Yes.
And three
Uh,
there.
Rest of them are victims, Your Lordship.
So state is representing one,
1, 2, 3.
or you're representing 1, 2, and 3.
Yes.
4, you are private respondent, you are respondent.
Yes, I want to permanent.
So now there are most probably 1, 2, 3, 4, 8. 8 numbers of respondents are there.
Your Lordship, if I may, Your Lordship, in this case,
Huh.
what has happened was there was an incident wherein the informants laborers were assaulted, Your Lordship. And therefore, the informant made an FIR, Your Lordship. Subsequent thereto, Your Lordship will see that a proper kaba was held, Your Lordship, wherein the accused were directed to the kaba imposed during the pendency of the FIR investigation. They have approached the kaba to Your Lordship. Now, kaba instead of leaving it to the investigation team, they have held a kaba proper customary court and they have imposed certain fines to the accused, Your Lordship. Now, only on that ground they have come that there was already a kaba and therefore this matter be quashed, Your Lordship. Now, there are 4 victims who had been injured by the accused, Your Lordship. All of these 4 victims are the laborers, Your Lordship.
Now, they are there.
There, all the names are not there, and all the victims are not being made a party, Your Lordship.
No, 4 is also a victim.
No, 4 is the informant, Your Lordship.
4 is the informant.
Only 2 of the victim, if Your Lordship will come to page number 22, Your Lordship.
No, you just tell me. Then 4, up to 4, they are not the victim, informant or the government side. Now 5, 6, 7, 8, 9, they are the victims.
Mine is only 5, 6.
5, 6, 7,
7,
8.
8.
I don't have any, my petition does not have any.
No, your petition will have it. 5, 6, 7, and 8. As per you, they are the victims.
Yes.
Huh?
Actually, this was amended maybe.
Yes,
This
amended.
was amended.
Oh.
My petition was amended. Yes, the service on this.
5, 6, 7, and 8. they are
Actually,
also
Lordship,
victims.
as per order dated 31/5/2023,
Ah,
the endeavor has been made to find out the exact location and exact address of the rest of the victim person.
Ah.
Any victims are the playing laborers. They were working under the informant, respondent number 4, at that point of time. Now, the informant, he himself could not find out the victim itself. And the applicant have tried lots of time to find out the victim. Even
now,
as per,
why am I insisting on the victims? Because if you go by this section, I don't know what is the charge sheet section, but the
Yes.
case was registered most probably under 326.
yes, initially charged is under 224.
Huh?
The case was registered under 326, but charged is under 324.
So definitely the sharp
Yes.
injury
Yes.
was there.
Yes,
Yes.
yes.
But in fact, in this, if there is an any agreement, it has to be done through the victim, and victim should be a main party in this case.
Yes, because they are victims to victims, and that apart the section, brevity of the section, it was earlier listed, whatever, it went down to 324. But still then, why they are not here?
Lordship.
Now what to do then?
Lordship, the chances of finding out the rest of the victim is remote, since they were the playing levels.
Now,
Even
if-
by order dated 31/5/2023 of this honorable court, we have tried to find out the victims through informant, and steps has been taken.
Your lordship, if the all the addresses are, if as per the submission, it's the proper address, your lordship, a fresh notice can be issued, your lordship, because even the father's name and the proper residence are being mentioned in the petition.
Yes, after the amendment, I don't know what was the earlier position, but the amendment, whatever. It seems that 6, 7, 8, there are some corrections and the name and address.
Yes,
So if these are the proper address, have you taken
Yes,
steps?
yes.
No,
No,
also.
No, your
steps have been taken upon this
No.
address also.
No, your lordship, after the amendment was, the amendment petition was filed, your lordship, direction for notice on service has not been made. If your lordship will see the last order, your lordship.
No, last order speaks to otherwise.
Yes, the first order was with regard to the old petition, your lordship, where they did not make them the party, your lordship. Subsequently, after making,
Order dated 31st of May,
Yes.
it says that it also submitted the several individuals have been taken made to find out the correct address of the respondents, and even after correcting the addresses
Yes.
of the respondents, and after taking steps, notices could not be served upon the so-and-so, call for this can probably be the matter. So that is-
so if they have taken the steps,
Yes,
your
still
lordship,
was taken.
What
their
was
new
the- What was
address
the report of the process or whatever? What is the report then?
The report.
Because why
Because-
I'm on the service of notices on the victim, because they are the person,
Yes,
most probably,
yes,
who sustain some sort of injuries. So they should be.
they
there.
should.
yes, but matter was amicably settled by the village authority
No, no, no,
during
no.
that point of
In
time,
this,
in presence of the
First,
victim also.
my first objection in this petition itself was that there was no amicable settlement. Though the Kaba was held, your lordship will see during the pendency of any case, especially during the investigation, can a case be taken up directly by the Kaba, because the jurisdiction entirely is with the investigation and the trial court. That was my first objection. However, the learned court had made an observation that be that it may, they were already imposed fine, your lordship. They were already held guilty and they were imposed fine by the Kaba. And therefore, though that issue was resonated, your lordship. Now my suggestion at that point was also that if they had come before this court under 482, this Kaba does not stand, because this Kaba itself is a court order imposing fine upon the accused, your lordship. My suggestion at that point of time was that even now, during the pendency of this application, parties can make an agreement, simple agreement signed by both the parties that so and so Kaba was held and we were already imposed fine, and that agreement may be brought to the court, and accordingly, if that agreement is being made and the parties have signed, even their presence or notice upon this would also by go, your lordship. That was my suggestion at that point of time.
And by the way, this is a good suggestion, and in fact, the question is, after the correction of the addresses, what was the report? Can you show me the office report?
Yes, lordship, we have tried and we have already.
Tried, no, report, what is the report? One report is there, we find the 25/7, notices upon the respondent number 5 to 8 received, unserved, with a note, addressee cannot be located.
The service were taken through the respondent number 4.
So respond number.
Yes, respondent number 4, he is a complainant informant.
In that case, service may, if the entire address is being given, your lordship, a service may be done through the jurisdictional police station of that particular area otherwise, your lordship. Because they have stated
So
that.
what you to say, well, your laborers, you do not know the proper address of your laborers.
I have no knowledge whether the service has been taken from my party or not.
Now,
No, not by your party.
Yeah.
He says that through you, it was.
he may be take through in person to the client. I have no knowledge.
In person.
Through registry.
Registry. No, you have said that through informant,
Yes,
through informant. you
through
have given-
informant. Yes.
So,
Through informant.
Through informant, how? How through?
As per
informant?
order dated 31 of 5 of this honorable court, the step were taken through the informant.
Through informant, it was
Yes.
directed.
Yes. Since the victim were playing laborers, to locate them in this stage is remote.
Now, if I may suggest, Your Lordship, if their submission is that they have served notice through the respondent number 4, Your Lordship. Your Lordship may direct them to take steps in the given address, not through the respondent number 4, in the given, because they have clearly given the address, the entire address, being along with the reference to their father too, Your Lordship. A fresh step may be given, a direction may be given to take fresh upon them through the regular service, Your Lordship. I mean, like AD card, Your Lordship. Not through respondent number 4, if the submission is made in that. Because respondent number 4 is not liable to send notice of this court to the parties in the region.
But earlier also.
No, respondent number 6, 7, 8, the steps were taken through ADOs.
AD
Yes, on 5th May 2023.
on 5th May.
Yes, 6th May.
It seems that was taken steps on 6th of May.
Yes, 6th of,
But what is it, was it a correct address?
yes,
Oh,
corrected address.
On respondent number 5, Your Lordship.
On the strength of
6,
order
7,
dated 31.
6, 7, and 8.
Then we can await the service report in that case, Your Lordship. This matter be listed in orders in that case.
But one order was passed on 31st of May
Yes.
at this court. Two weeks can be awaited if you see,
No, sir.
otherwise. So
Endeavor can
we
be
don't
made
have
out to take fresh step.
Even if I may suggest, Your Lordship, if 5 steps was taken on 5 to respondent number 4, we'll leave that part, Your Lordship. With regard to respondent number 6, 7, and 8, Your Lordship, all of them are from the resident of Lakhimpur, Your Lordship. All 3 of them, Your Lordship. And fresh notice can be issued through the jurisdictional police station, Your Lordship, because as per the address given, it's a permanent resident of.
One is to from Manipur also,
Yes.
possibility of searching them, right?
कौन सा Manipur, Your Lordship, no, Manipur.
8 is from Manipur.
Yes, serious.
District Manipur, that's it.
Yeah.
Sorry, district Manipur, that's it.
There must be another petition, Your Lordship. I don't have respondent number 8 in my petition in that case.
Shri Suresh Singh,
Corrected.
Tombi Singh is the demonstrated permanent resident of
District one.
Amba,
District one.
Kopi, village
Assam.
Maira, Vishnupur, district Manipur. District Manipur, state, which state he belongs?
No, Bishnupur district is that as Manipur.
Manipur,
Yes.
you are saying district
Yes.
Manipur. It is district,
Tamna Pokpi. District Tamna Pokpi.
State Manipur,
Is that Manipur?
so this is also wrong. Everywhere you have written district Assam, district Assam cannot be a address, no?
This address we have
Not
just.
district Assam, state is Assam, district, how district can be Assam? District is Dhemaji, Assam. District is Dhemaji, Assam.
Lordship, we
Oh,
have
Takeli.
tried our best to find and locate
Takeli.
the address of the
My-
victim
Dhemaji district will Nilefan or
through
district
every
Dhemaji.
possible sources. Lordship.
My petition has not even been corrected, Your Lordship. Therefore, I was so confused with regard to respondent number 8, still it's resident of.
So the number 8 is from Manipur.
Since the address of the victim is not mentioned in the charge sheet also. So we have tried our own sources to find out the victim. But
Let us have
it seems that it is remote to find out them.
Let us have it for 2 weeks. In that case, otherwise we have to proceed with. Because they are the victim, that's why that is the main question. And Kaba is.
Yes,
But-
but
And
Lordship,
apart from Kaba, there was no other documents you have.
no,
No.
we have bear the medical expenses of the victim also.
Definitely, we have stated this one,
Yes.
but who are the victim for whom you have been medical expenses?
All the
performed?
victims also, it is clearly stated
No,
in.
But yes,
contract.
in Kaba, whether their parents were there, they received the money, all things will
Yes.
come, so. Or otherwise, we'll see. So hard so and so, let us. Await for service of notice,
Correct.
count 6, 7 and 8. List after 2.
Interim is there also, interim may be continued.
Pardon, interim was there.
Yes.
Interim will continue till next. Okay, we'll see. And
The-
this time, if
Definitely.
the victims are not available, then we have to, in their absence, more around it.
The
Item number 5.
Five,
My lord, this would be the third time they are not appearing in this case, my lord. The issue
Absent.
is, yes, my lord, and the issue is very simple in this case, challenging the inquiry being conducted by the crime branch, my lord.
oh,
Yeah, for the setting aside of the inquiry, my lord.
ah. So it can be disposed of, I think, they have not appeared.
Yes, my lord.
One first occasion. Second, oh no. Last 2 occasions they are remaining. absent
Yes,
now.
my lord.
Petitioners. Petitioners are absent on call. From the record, it reveals that last 2 consecutive days, they remain absent without any stay. And hence, then the bulk will be next, if the consequential order will be passed on the next day. If they remain absent, if the petitioner remain absent, let the matter be listed after. One even one such.
My lord, similar nature of matter is fixed on 9th, my lord. Can this matter be fixed on 9th? Since there was a direction from this honorable court, they have filed an anticipatory bail application. And there was a direction to appear before the IO within a specific time. They have violated that
It
condition,
can be fixed on 9th.
9th, my lord.
9th of, 9th.
Much of it.
Then number 6 also, the petitioner side is absent, I think, no?
Yes. President, sir.
Sorry.
Joint petition.
This was the joint petition. Whatever they are absent today. The petitions are petitions are absent on call. In this matter, we heard Mr. So-and-so, the Raleigh Division PP, appearing on behalf of state respondent. This the matter accordingly on. This the matter accordingly after 1. Let us see. Otherwise, it was a joint petition.
Yes.
Under which section it was placed?
498. Between afternoon and 1.
Office note indicates that in respect of respondent number 2, service is still
Still
awaited.
awaited.
Yes. Also, lordship, when the notice was issued in this case on 29 March, LCR was not called for. I also forgot to mention and LCR may be called for lordship. So matter will be fixed after
Now
maybe,
it seems that you have taken steps on respondent number 2 when
yes, I have taken steps.
No, no, take a
Yes,
step.
the
On-
service
on
report is still awaited.
31st of March only.
Yes,
So still away, we are awaiting or.
yes. Through the,
But one order was there on first of, the office note is there on first of July.
yes.
That accordingly notice been issued through officer in charge. Or so
Ye-
you have taken
ye-
steps.
ye-
on that
Yes,
now.
yes. The, in respect of this report is not
Okay.
yet given. Matter may be listed maybe after 3 or 4 weeks. LCR also may be called for.
Is can copy of the LCR also.
Hard MS and your N Duggan.
And Duncan,
Dungan, hard MS N Dungan, Internet Council for the petition. So hard MS and Hadi Internet additional PP appearing on behalf of state respondent. From office note dated to 2023, previous that is service report on respond number 2 is still awaited. Poster, let the service be awaited till next day. Also call for this scan copy of the LCR. Matter will be listed after 3 weeks, will do, I think. 3 weeks?
No.
List after 3 weeks.
of lunch.
Of like,
Seems my lord, petitioner's side absent again.
Absent means they were seeking adjournment of the work.
This morning they tried to mention, I just simply asked them to let the matter come.
Yes, yes. Now, you have already filed your affidavit in opposition.
Yes, my lord.
So
They have filed even reply to that affidavit in opposition also.
so now why they're seeking for adjournment then?
I don't know. my lord, just-
They was citing one reason that Mr. D Hussain,
Hmm.
who was most probably the earlier leading counsel.
Hmm.
He has handed over the brief
Hmm.
to the newly engaged counsel. That was explained to me on morning.
That was their submission.
And as per you, they have taken adjournment on many occasions, I think,
They are enjoying
interim, na?
interim order passed by this honorable. So
Hmm.
for that interim order vacation, I have filed IA 28 of 2023.
So only 1 week can be given, I think. I don't know who he has been engaged now. He was appearing, was the council, now he's not here.
At least they should have wait.
Yes, yes, should have it. Or you are representing the state.
Yes.
Oh, that was called for.
That was called.
Acha.
Accused herein are absconding.
Huh?
Accused herein are absconding.
Accused is the
Absconding.
petition,
NVW.
And accused means the petitioner here.
petition.
They are the accused.
Yes, non-billable warrant also issued against them.
Actually, what happened in this case, my lord, that day I apprised this honorable court. On the pretext of giving me some contextual work worth more than 100 crore. They have fraudulently taken sum of rupees more than 5 crore from me. So thereafter, when immediately after getting that amount, they fled away from the state of Arunachal Pradesh. So we lost the FIR. That FIR it was registered. And in the meantime, IO has frozen certain bank accounts of this accused petitioner. So accordingly, we have filed JIMA application before the learned JMFC UPI hearing. And accordingly, that was allowed, that JIMA application, by giving us temporary custody of those seized amount. So that they have put to challenge before this honorable court by way of this revision petition.
But as per the report, they are still absconding.
Yes, this left.
Whether they have filed any anticipatory bail, etc. or
Yes,
Earlier it was,
What-
that was rejected by
Rejected.
this
what
honorable
it is,
IOV. Ahmad.
Ali,
Acha.
interpretation from Supreme Court.
Acha.
This honorable court has rejected the,
Acha, then he has went to Supreme Court.
and the matter is still pending in honorable Supreme Court.
Supreme Court. Or is it still pending?
It's still pending.
Acha. In that case, as what request was made in the morning half, so we can give at least 1 week time. Let us see, otherwise this status report will be in the report. You keep the status report, it can be kept in the record also?
Yes.
We can.
In that case, that may be reflected in the order sheet that the status report has come.
Yes, yes, I will mention.
And kindly then in that case, maybe on 16 August.
Uh, In I, you can write, one I is there along with criminal revision. Heard, Mr. K. Tama, the learned counsel for the petition, and also heard, Mr. Italo, the learned additional PP appearing on behalf of state respondent. However, it is submitted by the newly engaged counsel, that Mr. D. Hussain, the earlier leading counsel, has already returned the brief. And the newly engaged counsel he needs some more time to prepare the case and accordingly pay for an adjournment. Also, in it is also submitted that the status report has been is already received from the IO, which is submitted by the learned additional people. If the status report along with the case record, let the matter be listed on 16th of August 2023 with a direction to the other side to proceed with the hearing on the next day without stop. On the item number 12, you can write the councillor Namin, I don't know who was the council. The adjournment, the newly engaged council for the petitioner paid for an adjournment, stating that the earlier leading counsel, Mr. D. Hussain, has already handed over the brief. However, some more time is required to prepare for the hearing. Full stop. Considering the submission made by the learned counsel, let the matter be accordingly listed on 16th of 8, 16/8/2020. Both the matter will be listed on 16/8. If you think giving you time, short time, let us see.
Highly obliged.
Status report will be here. You are on 13?
No, my lord, 13, I cannot.
13?
Yes.
Yes, we are calling 13 only.
Service report is still awaited regarding this R2 respondent.
I'm appearing on behalf of respondent number 2.
Oh, you are for respondent number 2.
Yes. I
Achha.
filed the Bakalat number today.
Today you have filed wakalat number?
We are yet to receive the service copy. We have not received the service copy. The petition copy we have not received.
Okay, but petitioner is absent now, home to direct. Anyway, we'll make a direction here. The none appears on call for the petitioner side. I heard Mr. So-and-so, the learned additional PP appearing on behalf of state respondent, and also heard your good name.
Sinatun. Sinatun.
Sinatun, the learned counsel appearing on behalf of the respondent number 2. It is submitted that Bakalatama is a file, Bakalatama has already been filed on behalf of respondent number 2. However, it is submitted by him that they have not received the copy of the petition. Accordingly, the petitioner is hereby asked to provide the copy of the petition to the respondent number 2 during the course of the day. Let the matter be accordingly. So we have received the photocopy of the LCR also, no?
Yes, LCR received already received.
The scan copy of the LCR has already been received. Place the matter accordingly in the admission column in the next date after 2 weeks. So it will be listed for admission hearing. Admission hearing stays, it may be disposed of also. So get ready.
Hello. Lord.
Service is completed here.
Yes, we have taken the steps.
Most probably service is still awaited for respondent number 2.
Okay.
One state is 1, but respondent number 2 most probably still awaited. Steps we have taken steps, na?
Yes, Lord, we will be allowed to take first step and
Lordship, since this is the passing of FI lordship, then CD may be called for lordship. That's fine.
Quashing of the FI means it is not yet charged sheeted.
Not lordship, it is only
And
passing of the
investigation is still going.
lordship. This one lordship, stay has not been granted, so CD may be called for lordship.
CD in that case, too, we'll have to call for the scan copy, otherwise it will. affect
Yes,
the
lordship, that's why lordship, it can copy of the CD.
But there may be progress, I think, in investigation. Till we receive the no service report for the respondent number 2.
Lordship, service report for this, for the appearance lordship, for the respondent number 2 lordship. For the case study, we have to call from the lordship, PS lordship.
No, I am asking that.
Lordship.
Till we receive the service report of respondent number 2,
Yes, lordship.
we progress, the investigation may progress.
Yes, lordship,
further.
status report may also will be included lordship in that.
Heard Mr.
Lordship, I'm appearing on behalf of CW Manto, myself, H. Chada.
Heard Mr. H. Chada, the learned counsel appearing on behalf of Mr. C.W. Manta for the petition. Also heard MS Hagi, the learned additional PP appearing on behalf of state respondent. As per office note dated 2/8/2023, the service is still awaited for respondent number 2. Further, the additional PP has submitted that the scan copy of the case diary may be called for. Along with the status report, present status. Report. And let the scan copy of the case diary be called for accordingly along with the status report. And matter may be listed after
3 weeks.
3 weeks.
Like,
Service on respondent number 2 is awaited.
We still awaited.
Yes.
You have taken steps already.
Yes, Lordship. Lordship, this is for quashing of domestic violence case pending before the Chief Judicial Magistrate.
And that's why presence of respondent number 2 is required.
Yes,
Yes, it is a domestic violence. The state is a, though they are party, but maybe a formal party.
Yes.
So
And
who
Lordship,
is to
this-
receive party?
Yes, Lordship, this case has already been admitted.
Huh?
That once this,
Admitted?
yes,
Not.
no. Actually, Lordship, that once this case is decided, this case will be of no use. So, Lordship, my prayer is for interim order may be granted, Lordship. Otherwise, there will be no use of this case, Lordship.
Your Lordship, on
Domestic
the
violence.
first occasion, the interim prayer was also heard, Your Lordship, and therefore the learned court did not stay the
No,
matter.
Otherwise also it is a case of PWDB Act, Domestic Violence Act or what?
Yes, domestic
Yes.
violence.
Domestic violence, how can it be distinct?
Now, Lordship, this but one. Lordship may come to 27.
Now we say, when did the next date is fixed?
Lordship, that I'm not aware of this.
Next date of the trial court, when it is fixed?
Lordship, but this is not mentioned. in particular.
Or what is the stage of the case?
Lordship, it is, I think, for the witness stage, Lordship.
Witness is still going.
Yes.
There is a-
Evidence is-
In fact, the court has passed an order for interim maintenance also in the domestic violence case, Your Lordship.
That cannot be,
Therefore,
domestic violence. Act
No,
cannot
Lordship,
be
then
stayed.
this, at least this witness may be stayed, Lordship.
No,
this-
that is stay only, witness is stay when it's.
Oh, sorry, Lordship, this order for this interim.
No,
Lordship,
that cannot
maintenance.
be stayed. In the domestic violence cannot be stayed. Now that's why I'm asking you, what is the next date fixed? So that we can help you some way if we can be fixed prior to the date fixed by the trial court. That's why I was asking, if you can collect the date, just inform us, we can fix the date accordingly.
Lordship.
Otherwise, you write, hard Mr.
G.
Yes, eh?
G. Kata.
We are on?
G. Kata,
Which-
Lordship.
No, we are on very 16, na?
16.
Yes, they heard Mr. G. Kato, the learned counsel for the petition, also heard MS Tijini, the learned additional PP appearing on behalf of state respondent. However, from the office note dated 2/8/2023, it is seen that the service is still awaited for respondent number 2. In the meantime, we can call for if scan copy is required.
Yes,
Yes,
yes.
yes,
can go-
Still awaited in the meantime, let this scan copy of the LCR be called for. Call for, full stop, let the matter be accordingly listed. Listing, we'll see if you can inform us. We'll try to fix the date prior to the next date fixed by the trial. So you just inform us. Date you keep it blank. We'll try to give a date. Agote, we can give it
Okay.
in advance, okay? So
Okay.
we are waiting, you just tell us about the date, if you can collect it. Otherwise, we'll give you our. Deeply. Now, this is a domestic violence, it cannot be stayed, let us see. what happens. Here also, you have taken steps on.
Already established,
steps.
yes.
No, your lordship,
Actually,
this
this
is a
matter
joint petition.
supposed to be,
Oh, this is a joint petition?
yes, accepted in
Okay.
admission hearing. My lord, this is a joint petition filed by the victim and the accused person. My lord, brief of the case is that, in the year 1998, this petitioner number 1 and petitioner number 2 had developed a relationship. Their relationship turned into a love and affections. Love and affections.
Love and affection was there.
Yes, my lord.
Huh.
Then after that, my lord, what happened? This number 1 and 2 eloped from the Changlang to Margarita and stayed here. On receipt of the information of the elope, the father of the petitioner number 1 lodged a complaint before the police station, stating that his daughter has been kidnapped by the petitioner number 2. And accordingly, the case was registered. After that, my lord, this case was settled by the parties. And my lord, kindly see the page number 46. This is the withdrawal letter filed by the informant, the father of the petitioner number 1. My lord,
For
this,
deputy commissioner,
yes, at that relevant point of time,
he wants to withdraw the.
yes, the deputy commissioner holding the power of the judicial magistrate. My
Before
lord,
separation of.
yes, before separation. My lord, may I read the content of the subject statement regarding the false allegation charge of kidnapping against Sri Samuel Modi in Changlang PS case number such and such. Sir, most respectful, I beg to submit that following statement before your necessary action and consideration, please. That sometime in the first part of 1999, this my page number 46. While referring to the above cited subject, I would like to submit the following facts for your necessary action and consideration, please. That Miss Orna Chetri is my daughter, born out of my wedlock with Srimati Sasansak. My daughter had developed intimacy and relationship with Sri Samuel Modi, Constable First Ireland, sometime in the year 1998. After his posting at Changlang, the intimacy and good relationship developed in between them. I lodged an affair before the police station Changlang, and accordingly it was registered as Changlang PS case number 15 of 1999 and GR case number such and such. During the investigation, the IO of the case had seized the handwritten Hindi letter of dated 6/8/1999, written by my daughter, namely Miss Orna Chetri, to Sri Samuel Modi. That Samuel Modi was arrested, and after his release on bail, an intimation of intention to settle the matter outside the court was already submitted to the Court of Deputy Commissioner Changlang. Accordingly, the matter was settled, and thereafter my daughters, namely Miss Orna Chetri, has also got married to Nepali wife. Out of their wedlock, my daughter has become mother of 2 daughters, and now she is enjoying her married life with her husband and daughter at Changlang peacefully and happily. In other side too, Sri Samuel Modi also got married and living with his wife and children at Pasigat. That during the pendency of this case for last 8 years, both Sri Samuel Modi and Ms. Rona Chetri, both married to person belonging to their respective community and enjoying their married life peacefully and happily. It is anticipated that the reopening of the trial of this case will jeopardize and affect their married life badly, and it may shatter their married life. In view of the above stated circumstances and the facts, Your Honor is free to admit this application and on perusal of the record, and also sensing the gravity of the effect of the trial of the case to their married life, I am permitted to withdraw the case registered on the basis of affair lost by me on 24/8/1999 out of angry for the interest and end of justice. My lord, this withdrawal letter was submitted by the informant, the father of petitioner number 1. After submission of this withdrawal letter, he expired. Who? This father of the petitioner number 1. Yeah. My lord, this is the case of 1998. So, my lord,
Father already expired,
yes.
the informant already expired.
already expired. So, my lord, this case relating to the love and affections of the parties, and both the parties have jointly filed this application. My humble submission is if no objection from the.
How can we identify the informant now? Sorry, the victim.
Your lordship, if I may take your lordship to page number 49, your lordship. The same set, your lordship will see at page number 51. This was also made on the same day when the father has made a representation to the deputy commissioner, your lordship. The victim had also filed on the same date, your lordship will see at 51, yes.
It was filed by her also.
Yes.
So what was the result after the filing of the withdrawal? Was there any order from the deputy commissioner?
My lord, this case now transmitted to the Session Court Teju, and now Session Court Teju has summoned the accused person.
No, prior to the withdrawal letter regarding any order was passed by.
No
the-
order passed. No order passed.
Now it is pending before Teju.
Teju Session Court.
Session judge.
Yes, my lord. Well, this problem is that if this case is reopened, the problem is that this petitioner number 1 is a lady, so it may affect his married life.
Now 368 is also there. Was there any other accused?
No, my lord.
Why 368 was there?
No, yes, there does not seem, even the FIR does not refer to any, your lordship.
Any other?
My lord, actually, this charge sheet section are not affected at all.
The only fact was that she was a minor at that point of time, your lordship, but then withdrawal representation clearly states that she had in fact voluntarily gone along with the accused. So that's our statement.
Now she got married with another.
Yes, both the parties married.
The petition will be allowed. Will pass. Here, state is also only appearing. In any other, no.
It's not, worship, Erica returned back from OCPS Pasiga, but service report is yet to be received.
No, it is a case of the hearing stage, na, that's why I'm asking. It is the hearing stage.
But yes, I get it.
What nature of case? Nature of the cases?
376.
376.
Yes, 376 one.
So he already been fixed for hearing, then you make submission what to do. Most probably victim is and she is not appearing in this case.
Yes, victim.
But case has already reached the hearing stage, so we have to hear him. What to do? Case is already the hearing stage, na? Paperwork is also, I think, ready.
Yes, probably.
Last order. Inspector so there's no order of that, he is still awaited or something like, it's already fixed for hearing only.
Yes, it is in office note.
Whatever, this
Yes.
case is for hearing only. You could have raised those questions earlier also. It's already reached to the final stage and it's hearing for hearing. only. One order was there on 25th of May, that there is no reflection in the office note whether the notice has been served on the victim plus the opposite party number 2. In view of that, the matter of raised to verify whether the steps of issuance of notice upon respondent has been taken or not, or whether it has been duly served or not. That much only. Thereafter, no order is there, and it's simply listed after vacation, list so and so, so and so, this thing. I don't
Yes.
know why it just came for hearing stage, I don't know. Who, have you taken steps on respond number 2? Respond number 2 to officer in charge, Pasigat so and so by registered AD, make and delete the form. Order this rate is received by the AD card from PSC. Till that this service report. So there was an office note on long gap after 7/12, there's an office note on 14/6/2022. As per the said office note, service was most probably still awaited, but thereafter, don't know what happened. It is not, and it's not reflected anything here in this case.
Edica returned from OCPS, but service report is yet to receive. Whether step has been taken by OC or not.
The AD card, that is different thing, AD card return receipt, and the service to jurisdiction police station is not yet received.
Not yet received.
Issued upon the respond number 2 to officer in charge, Pasigat. Oh, that was to register it only.
Yes.
No, yeah,
That
notice
AD
was,
card.
notice
return
was served through the OCPS,
Through AD.
through the
Through register post.
register for. So ideas returned. So it is presumed to be served. Notice has been presumed to be served.
AD card is here. It is received, I think, now.
The man is interested now by this time.
Huh?
The victim man is interested.
One signature is there, I don't know whose signature is there, but it is returned.
Yes. Registry.
There is no note that it is returned unserved,
Yes.
or it is not rejected, it is returned. So that is returned, I think. That been served, or what?
So this is presumed to be served.
Can be presumed to be served then, otherwise. Oh, yes.
I'm not sure, but I suppose your worship, this notice was sent to OC by registry through register post. And OC returned the AD card. But it is yet to confirm whether victim has received the notice or not.
How long will be waited? This is the appeal most probably from 2019.
Then,
Why let's make any submission in that regard?
then
This is not there.
amicus may be appointed for victim. Because participation of victim is now, it becomes mandatory.
That is why I'm saying that. To do one thing that the AD, as per your submission, AD returned from
OCPS.
OC.
Notice was served through the OCPS.
No. As per his submission, we have sent the notice to OC through registered post. That notice has already been received by the OC, and that's why the
AD card returned.
But the question is whether notice was served to the
Victim.
respond number, that is not there.
It is reflected in
Then
office
then
note.
we can do one thing, because cases of, where is the appellant now? He's still inside the jail or no?
No, appellant is in the on bail, in bail.
Is in bail. We can do one thing. At best, we can appoint an amicus And in the meantime, you can serve notice through jurisdiction police station also. Let us see if report comes and all right. If report doesn't come also, then amicus curiae will be will be representing the victim. In that case, it can be heard finally. Because no order is there. I don't know why.
Actually, last, that was 27 February 2023. And but on that day, court was not sitting.
No, 28/4/2023 was last date.
Oh, that is not in my record,
That
sorry.
the SEMA was.
Sorry, I have.
In that case, amicus curiae may be appointed without going through the, again,
No, we are going to appoint the amicus curiae today, sir. We are going to. Heard Mr. M. Partin, the learned senior counsel for the appellant, and also heard Mr. Swain, the learned additional PP appearing on behalf of state respondent. It is submitted by the learned additional PP that the service is not yet completed on respondent number 2, though the ID card has been returned by the OC of the concerned police station. Stop. It seems that the appeal is of 2019, and hence I find it prudent to appoint an amicus curiae on behalf to represent the respondent number 2. In the meantime, the appellant will take first steps on respondent number 2 to OC of the jurisdictional police station, and registry will do the needful in appointing the amicus curiae. In the absence of the respondent number, in case of absence of the respondent number 2, the amicus will do the needful on behalf of the respondent number 2. Let the matter be accordingly listed for hearing on. So we can wait, only 3 weeks can be wait. 3 weeks can be awaited, then thereafter it will be fixed for final hearing. In the meantime, I have already passed an order for appointing an amicus. If she appears or upon some other counsel or whatever, in that case, amicus, there will be no amicus. Otherwise, amicus curiae will be appointed. I have already passed the order, so that he or she may not remain unrepresented. Okay, is there any submission from your side?
No.
At least after 3 weeks, amicus will be already appointed. Amicus is already appointed, so he will represent the victim on the next occasion, even if the service is not completed. Okay.
Obviously.
And because it is a case of 376, so it
Yes.
will be represented by someone at least. That's right.